As a constitutional law attorney, former senior legal advisor and personal counsel to President Donald J. Trump, Jenna Ellis believes in the rule of law and the importance of integrity in our elections. And she's ready to tackle the big cultural and legal issues facing America. This is the Jenna Ellis Show. Here is your host, Jenna Ellis.
Hello, friends, and welcome to another episode of the Jenna Ellis Show. Well, today we have a lot to discuss. Tucker Carlson last night, he issued the first installment of the transparency of the January 6th videos. And so a lot of what came out in those videos had not previously been seen by the full public. And specifically, the so-called QAnon shaman videos showed that he was actually escorted throughout basically the entire U.S. Capitol by police. So does that change the nature of his plea agreement? The question that I have is whether his defense attorneys had access to those videos. There is a very big difference between transparency in terms of public interest. I think that is a huge issue. And of course, all of the video footage should have been released to the public long before Speaker McCarthy came along and actually gave this to Tucker Carlson. I think that's a great idea. We need to know the truth. We've had some suspicions, but we all need to know the truth about what happened. But even more importantly, the defense attorneys who are representing individual clients and defendants of January 6th prosecutions have to be able to access all of the footage related to their cases. So were there so-called Brady violations? The standard, of course, is the Supreme Court case in 1963 called Brady versus Maryland. That case stands for the proposition that anything that is in the government's possession that is exculpatory or tends even to exonerate the defendant of the crime for which he or she is accused has to be given over to the defense. Of course, this makes sense in a fundamental fairness and due process protection context, because when the government withholds any information from defense attorneys, then you can see how prosecutions can be railroaded. So I'm going to talk about that more and what we've learned from some of the filings from the DOJ as well as defense attorneys in the context of an interesting separation of powers argument. So my good friend Ron Coleman, who is an excellent attorney, is going to join me right after this to talk about more. Legacy Precious Metals is the company that I trust to give you good and patient counsel for investing in your retirement. The Biden administration has caused a financial crisis, and they have no clue how to fix it. Oil prices have skyrocketed, and when oil prices go up, not only do your expenses go up, but the cost of transportation and shipping spikes, leading the prices of goods to rise. And we are already seeing record inflation. That's the last thing that we need. Our economy is in trouble, and you need to take steps to protect yourself. If all your money is tied up in stocks, bonds, and traditional markets, you may be vulnerable. So gold is one of the very best ways to protect your retirement. No matter what happens, you own your own gold. It's real, it's physical, and it's always been valuable since the dawn of time. Call Legacy Precious Metals today at 866-528-1903 or visit them online at legacypminvestments.com. That's legacypminvestments.com, where you can download the free investor's guide. You can also go to my Facebook page, Jenna Ellis. I am a public figure on Facebook, and I just posted yesterday a really great interview with the president of Legacy Precious Metals, who is discussing why you need to start your retirement account even if you're in your 20s or 30s. There is always a great time to protect your retirement and invest, just like you want to protect your health over the long term. So go to Legacy Precious Metals at legacypminvestments.com or call 866-528-1903. So joining me now is Ron Coleman, who is a partner at the Dillon Law Group. And Ron, I want to get to the January 6th videos and Tucker's whole segment last night. And, you know, there has been a lot of Twitter commentary over this. I think a lot of questions that are frankly really irrelevant to the legal questions here. So just off the top, what was your general overall assessment of what Tucker said and what these new evidence videos reveal?
My overall reaction was that the release of the videos only confirms what everyone assumed was the fact when they refused to release them in the first place. Anytime someone doesn't want to show you something, you may safely assume that it is not to his benefit to show it to you. This is an outrageous constitutional, ethical, and moral violation. Everything that the January 6th committee has been about has been a series of violations of that nature. And this business with what's amazing to me is how they have played the reaction as if they're the offended ones. It never ends.
Yeah, and Chuck Schumer actually went to the Senate floor today to disparage and try to discredit Tucker and all of the Democrats. And of course, by Democrats, I include Adam Kinzinger and Liz Cheney in that group. But basically, anyone who has been against the full transparency of all of the January 6th video footage, really, it does paint them as people who want to hide something. And, more transparency is always a good thing. And the committee in its inception would not allow for the then minority party, and we should all remember this, to put on their selected members onto the committee. We only got the two Republican in name only, Liz and Adam, and we really didn't have any sort of effective cross-examination during the hearings. It was basically a modern-day Star Chamber. So for the public interest, I think that this release of the videos is very important so that everyone can have a very clear picture of everything that happened that day, not these isolated snippets that may have been clipped out of context. But to me, the most important question here is what happens to those people who have been prosecuted as a result of their actions and attendance and whatever they did on January 6th. And the question for me is why the Department of Justice has apparently litigated this issue regarding what the defense attorneys were allowed access to. And apparently what has now been revealed through a lot of the filings and some of these other things have been that the Department of Justice basically said, well, this is a separation of powers issue. If Congress doesn't want to give us Brady material, which of course is, as you and I know as lawyers, is any exculpatory evidence or evidence that tends to prove the innocence or the non-guilt of the individual for the offense charged, that's required for the government to hand it over. They can't just selectively prosecute either. But the Department of Justice here is saying, well, this is up to Congress, and because they're a separate branch of government, we can't compel Congress to turn this over. So sorry, we're just going to go ahead and be limited to what we can provide the defense based on what's in our possession. Isn't that kind of an incentive then for the government as a whole to simply say, well, Congress can keep this, don't give it to us so that we don't have to turn it over?
It is, but I'll do you one better. It's not only provides all the wrong incentives, and of course, all constitutional amendments apply to the government, not to a single branch of government. So the argument would not be that the Justice Department or that even that prosecutors violated our rights, but rather that the United States, which is, after all, the entity on behalf of which prosecutors style themselves as bringing charges and prosecuting cases, the United States of America is responsible for the Brady violation. But there's also another point here, which is that it's actually the exact opposite of what the prosecution says. Congress, the position they're taking is essentially that they have no obligation to make an effort to get the complete record, and they can be willfully blind about the existence of alternative information. I mean, the separation of powers issue is exactly the opposite. That's really what I meant to say is the opposite here. The separation of powers issue is Congress is not in the law enforcement business. Congress has oversight responsibility with respect to everything the government does, but it's not in the law enforcement business. Once the January 6th committee started behaving like an arm of law enforcement, including by, as you put it, establishing this Star Chamber proceeding, it no longer can rely on the separation of powers argument. And the Justice Department can't either, because they're working hand in glove. If they want to say, If the Justice Department wants to say, we can't make Congress do anything, then you should have said to Congress, we can't use this material because it's not complete. And by the way, did they serve, if their position is that they're a separate entity, did they serve a subpoena on Congress? Now, that would have been an interesting separation of powers argument.
Right. Well, and I think what's so interesting here to me, Ron, is that it does give all of the wrong incentives. And the separation of powers as an argument is so that the executive does not encroach on the province of the legislative branch, and the legislative branch doesn't become the executive in terms of law enforcement. It's not to say that they can use that argument to shield them from their obligation for due process in the context of a criminal prosecution. And so what I'm really concerned about, and what really I don't think I fully understood in terms of, because I haven't been, as closely following the ins and outs and all of the filings on all of these cases as some others have. I'm not, attorney of record or a party to any of these cases. And so what has become really apparent through some of the filings that I have read today now is that some of these defense attorneys were required to sign stipulations that they could only access the video in a secure facility, and they could only access whatever the government said was related to their individual client, not necessarily the entire scope. I mean, this is just as ridiculous as saying, okay, we have some co-defendants in, let's say a bank robbery case, and we have a bunch of different cameras, but you can't, as a defense attorney, view the entire scope, only where your client actually shows up on the video. I mean, that would be an absurd argument, but it appears that judges here, the federal judges, went along with this. And so why aren't any of the defense attorneys raising these kinds of objections? And if they are, I mean, this would seem like this should be a very clear violation of the Brady rule that has been a standard in the United States from the Supreme Court case Brady versus Maryland since 1963. I mean, this is settled law here.
These are incredibly serious Brady violations, and they're violations of due process. There's a serious problem with the federal district, but the U.S. District Court for the District of Columbia. There's a serious problem with the Court of Appeals for the District of Columbia. It is a rogue court. It has been permitted to get a lay really by the U.S. Supreme Court, both through the Court of Appeals, with its own brand of justice for a very, very long time. And judges have gone on record, as has the outgoing chief judge in this district, as essentially admitting that a different set of rules and a different rationale for ignoring the Constitution will apply in January 6th cases because of the politics. They are the people who have been incarcerated in connection with January 6th, whether or not they are guilty of felonies or even misdemeanors in some cases, but whether they may be guilty of crimes, but all these prosecutions are political prosecutions. There's no serious question about that.
Yeah, and I think that that's what is really frustrating to a lot of people who see these due process violations and who are seeing this as more politically motivated, simply to try to first use this as a pretext for the second impeachment of Donald Trump that ultimately failed, giving rise to the 14th Amendment cases and concerns that were ridiculous, trying to use the insurrection clause. That's the only reason they use that term, to try to get all of these members of Congress who objected to the Electoral College votes that day to be prevented and prohibited by law from holding federal office. I mean, all of these things are just trying to manipulate and pervert the Constitution and due process to their political advantage. And that's what's frustrating to so many people here. So in the context, though, of someone like the so-called QAnon shaman, or Jacob Chumley, I believe is his actual name, and he pled guilty. There wasn't a trial. So, when Tucker's talking about, evidence that didn't come out at trial, well, specifically to the people who took a plea agreement, A lot of people are wondering then, well, could those convictions then be overturned on appeal if there was a Brady violation and those convictions and essentially the plea be withdrawn and have to go through the potential process? But here's someone who's already spent the last 2 years in federal prison. So if that ends up that the case is ultimately dismissed, this is the type of thing that is a huge miscarriage of justice.
Well, there's no question that there's a huge miscarriage of justice involved here. But frankly, given what we already knew about his particular case, his plea never made a lot of sense to me anyway. I don't know much about his mental health. I don't know much about the choices. One thing we always say, Jenna, as you know, is that if you don't have the whole red weld, you never really know what considerations cause a legal team to make what choices. I mean, we knew that this guy was connected to the government in strange ways that didn't seem to be consistent with the way they threw the book at him, that he was clearly unmolested even before these new videos came out. This was not someone who was easy to slip, whose appearance would allow him to easily slip past security. How he was able to get into the chamber, and put on this show, it was obviously a setup. Why he pled, under what circumstances, what really else was going on, it's simply impossible to say. But is a major investigation appropriate here? Is a major ruling, probably by the United States Supreme Court, going to be what it takes to get our arms around what's going on here? Perhaps. There's a gigantic problem. Yes, that includes people who pled, and certainly there's going to be a lot of, a lot of filings taking place, trying to reopen pleadings. Trying to reopen cases that were pled out on Brady grounds, and even to the extent that Brady limits. We learned a lot about the process of pleas, in particular, the law of pleas in this circuit in connection with General Flynn. What we saw in the ruling by the Court of Appeals in the General Flynn case was that the Constitution takes a backseat to political aims. But ultimately, under the law, there's really no question that, as you explained, a gigantic miscarriage of justice has taken place here, and every effort has to be made to push these cases forward, and also one of my Twitter friends made an excellent point, which was that, I guess it was DC Drano, there need to be complaints filed against a lot of prosecutors.
Yeah, and this is where if there was a knowing Brady violation or there were any sort of ethics questions here, then, a lot of these prosecutors, they are held to a higher standard. And this is true for federal practice as it is in state practice, that there is a specific professional rule of responsibility that attaches to prosecutors because our system recognizes that the government can maliciously prosecute, and the government has all of the tools available. And generally speaking, it's the government that has all of these investigators and has, whether it's Congress or law enforcement, police on the ground, whatever it is, has a lot more access to information that if they shield it from the defense in order to either maliciously prosecute, coerce a plea agreement, or any of those things, then they are held to a higher standard. And so I think it's going to be very interesting, Ron, to see what happens. And yeah, go ahead with one other comment.
Well, just that the transparency wise, there's no question that, what you said at the beginning about the separation of powers argument and what you said a couple minutes ago about the idea that the Justice Department itself was requiring attorneys, defense attorneys, to sign off on the fact that they were not going to be granted full access to all the information. Those things are not consistent. That means that prosecutors had more than they were showing. And whether we take the additional leap of saying that you can't hide behind Congress, there's no question that prosecutors themselves committed tons of Brady violations. When I say no question, I'm saying without having the red weld, we know it. We know it. I've spoken to many of, and I'm in regular contact with many of the J6 defense lawyers. This is a tragedy.
Wow. Well, it will be really interesting to see whether judges are fair in these cases and what types of appeals are filed. And so certainly, I'm very interested to follow this story. And I think for all of America, we really want to see that our system of justice is genuine and it's not politically motivated, depending on what party is in power. And this is why, for sake of the country, due process is so essential. This is why most of our Bill of Rights concerns protections and due process protections in the course of a criminal prosecution, because our founders recognized how easy it is for government to override the rights of the individual that results in their deprivation of liberty, which is the most essential right that we cherish and the government is obligated to protect. So this is just horrendous. But in the last few minutes that we have with you here, Ron Coleman, I also wanted to get to another story as well. You and I talked about this actually on my radio show yesterday morning about the Florida blogger legislation. And you and I both agreed in the context of this state senator that's sponsoring legislation that would essentially require any bloggers to register with the state if they write about Governor Ron DeSantis or any other high-level executive officer, and are receiving compensation, and to essentially be subject to fines and fees if they don't comply. You and I both agreed this is totally unconstitutional. It's antithetical to the First Amendment. Well, I think Governor Ron DeSantis may have been listening, because today in a press gaggle, he actually came out strongly condemning the legislation on First Amendment grounds. I'm very, very pleased to hear that. I think that was totally the right move. But I wanted to unpack this a little bit more with you here for our Salem audience, because I think that this legislation, while potentially, well-meaning to fight the fake news, and we all agree that, these kind of malicious and defamatory types of articles have no business in our mainstream press, we still have the ability to litigate that, even though I think you and I would agree New York Times versus Sullivan, the seminal case on this, needs a little bit of restructuring in the context of our, what we're looking at in the 21st century. But I don't think that this is the right way to go. And I think it's very dangerous that Republicans are advancing something like state regulation of blog posts.
You're 100% right. And indeed, we did agree. And in fact, one of the things I was saying as we ran out of time yesterday was that there is a tension between the good government value of transparency and free speech. The Supreme Court has said many times that anonymity is a protected constitutional right. Now, anonymity tends to degrade the quality of discourse, as anyone who is on Twitter knows. But it does give people the ability to speak free from concern of retribution. Similarly, anonymity of what motivates a person, I'm stretching the metaphor a bit, but a lack of transparency about what motivates a person, whether it's direct payments from a political campaign or the wish to advance one's career or the wish to get in good with the cool kids, in the communications business or whatever, or the media world, whatever it might be, people have all kinds of motivations. There's no particular reason that political motivations that are the result of payments from political campaigns should be disclosed any more than any other motivation, except that we've gotten used to this kind of regulation. We understand, again, the sort of the good government, desire behind this, but it's an awful idea.
Yeah, and this is where the tension points, I think, of how we are advancing in the 21st century with how political literally everything has become. And it's not to say that, there weren't these same concerns at the very founding of our country. This is why some of our founders even wrote under aliases and nom de plumes. And even though, later it came out and we are fairly certain, which founder wrote what document, That type of anonymity and the ability to write under a pen name for the purpose of not engaging your own name in politics and attaching it to that writing is something that, of course, is protected in this country. And for bloggers who, whether or not they're paid, that shouldn't be up to the state necessarily to regulate or to require transparency. As you and I were talking about today, and for those who missed that, you can go to afr.net, AmericanFamilyRadio.net. You can listen to the full program yesterday. Ron very graciously joined me for most of the show yesterday, and we talked about this at length. But, this is something that we can't go overboard in trying to combat the fake news and then forget that those same types of regulations can then be turned on conservatives who want to criticize our government. Criticizing our government is, of course, a foundational principle and right that is protected under the freedom of the press and under an ability to freely engage in speech. And if we try to regulate that as Republicans, then we are not going to like where that ends down the road in precedent. So I'm very glad to see that Governor DeSantis came out very strongly condemning that today. I hope that it's withdrawn by this state level senator, and we do what we can in terms of transparency. And I think a lot of people, Ron, what you and I talked about yesterday as well, is that a lot of people are very aware that, bloggers and influencers and others are paid. Of course they are. And they're paid for their opinions. And obviously someone who wants to write liberal leftist content isn't going to necessarily get hired by a right-wing outlet. They're going to go to some of the other outlets. And so you can be pretty much guaranteed that someone who's writing for Huffington Post is not going to have anything particularly nice to say about Governor DeSantis. We all know that, but we all see the bylines, we see the publications, and we can think for ourselves and analyze, do we agree with that criticism or not? I don't think that this is appropriate, as we've said, for any sort of government, state or federal legislative oversight.
It also wouldn't work. As a practical matter, it would end up being a whack-a-mole process. We are aware, all of us, of so many putative, nonpartisan, IRS-exempt organizations that are nothing more or less than shills for political parties on both sides. So if you were able to demonstrate that the ACLU paid to place a certain op-ed, okay? Well, the ACLU is a branch of the Democratic Party. Everyone knows that. The Anti-Defamation League is a branch of the Democratic Party. Everyone knows that. What have you accomplished? What have you gotten? You're not going to find out that it's like when people wanted to see Donald Trump's taxes. Did they think they were going to find, even under their most elaborate scenarios, bribe from Putin, $4,000 per day? What people just don't seem to understand how the world works. They go for what we really have to admit is symbolic lashing out, and that's what this legislation really would have been. It's got to go.
Yeah, very, very well said. Well, Ron Coleman, thanks so much for joining me today. You can subscribe to his podcast and listen to all of his great insights at Coleman Nation, which is the podcast, and also follow Ron on Twitter as well. And you and the Dillon Group, our good friend Hermeet Dillon, do such a great job, not only in your commentary and your analysis and standing up for freedom and the Constitution, but also in an actual litigation context. So we wish you the best on all of the cases and the hard-fought battles that you are currently fighting. So thank you so much, my friend. Looking forward to talking with you soon.
You're welcome, Jenna. Thanks a lot.
Well, friends, you must start taking care of your liver now more than ever. Why? Well, because the latest data from the American Heart Association indicates that adults with fatty liver were 3.5 times more likely to have heart failure than those without. The American Liver Foundation says that 100 million Americans have fatty liver, which means many people are still at risk. We throw everything at our livers: cholesterol, alcohol, toxins, Tylenol, statins, cigarettes, you name it. That's why so many of us have a sluggish, fatty liver that makes us gain weight and lose energy. For decades now, your liver has helped you with over 500 key functions every day. So it's time to help your liver and give back. Here's the solution: Liver Health Formula, an all-natural supplement which contains 12 clinically proven botanicals that help recharge and protect your liver. Manufactured right here in the USA and approved by American doctors. You can try Liver Health Formula and receive 5 free gifts when you order today. First, you'll receive a free bottle of nano-powered omega-3 to keep your heart healthy. You will also get 4 free ebooks to support every aspect of your health. So try Liver Health Formula today by going to getliverhelp.com/Jenna and claim your 5 free bonus gifts. So that's getliverhelp.com/JENNA. Legacy Precious Metals is the company that I trust to give you good and patient counsel for investing in your retirement. The Biden administration has caused a financial crisis and they have no clue how to fix it. Oil prices have skyrocketed, and when oil prices go up, not only do your expenses go up, but the cost of transportation and shipping spikes, leading the prices of goods to rise. And we are already seeing record inflation. That's the last thing that we need. Our economy is in trouble and you need to take steps to protect yourself. If all your money is tied up in stocks, bonds, and traditional markets, you may be vulnerable. So gold is one of the very best ways to protect your retirement. No matter what happens, you own your own gold. It's real, it's physical, and it's always been valuable since the dawn of time. Call Legacy Precious Metals today at 866-528-1903 or visit them online at legacypminvestments.com. That's legacypminvestments.com, where you can download the free investor's guide. You can also go to my Facebook page, Jenna Ellis. I am a public figure on Facebook. You need to start your retirement account even if you're in your 20s or 30s. There is always a great time to protect your retirement and invest, just like you want to protect your health over the long term. So go to Legacy Precious Metals at legacypminvestments.com or call 866-528-1903.